Welcome back to the deep dive. Today, we're stepping into a legal territory that is, well, it's arguably one of the most complex and fascinating in the world.
It really is.
We're talking about the foundational guarantees of individual freedom in India. We are going to try and decode India's fundamental rights, those bedrock guarantees that really form the soul of the world's largest democracy.
And it's such a spectacular area to study because the Indian Constitution it wasn't drafted in a vacuum or some moment of pure revolutionary idealism.
No.
It was a conscious, deeply thoughtful synthesis. The framers were actively pulling from these very divergent, sometimes completely conflicting global legal traditions.
The US, the UK.
US, the UK, and beyond, yeah. And they used them to create a framework that was, uniquely suited for India's history, its challenges, and its future.
That careful selection, that synthesis, is exactly why this deep dive is so necessary. Our mission today is to unpack that unique constitutional compromise. The compromise between these vastly different legal philosophies about rights and state power. And then we're going to chart the truly dramatic history of how these rights were tested, challenged, and ultimately redefined through some fierce judicial battles.
Yeah, we're looking for those key aha moments.
Exactly. The moments of legal compromise and conflict that really shape modern India.
And if you walk away with one thing today, it should be the answer to our big question, which is really structural.
Okay.
How did India manage to create a system that somehow balanced the potential omnipotence of Parliament, a concept taken straight from the UK, with the supremacy of the judiciary in protecting basic liberties, which is, of course, a concept borrowed from the US.
And that's the central tension.
It is. And maybe more dramatically, what happened when one of the most basic, most contested rights, the right to property, got caught right in the middle of that balancing act.
Which led to a constitutional showdown.
A showdown that ultimately defined the limits of Parliament's own power. It's an incredible story.
It is. So let's start at the beginning with the global context.
To really appreciate the genius and, let's be honest, the complexity of India's solution, we have to start with the two foundational legal models that came before it.
Okay, the two extremes.
They are, philosophical and structural opposites in how they even think about and protect individual rights.
And these two, let's call them the legal parents of the Indian system, the English model and the American model, they approach the very definition of a right from just fundamentally different places.
Let's start with the English tradition first. It's characterized by centuries of evolution, not revolution.
Yeah.
And what's critical here is that England operates under an unwritten code of fundamental rights. There is no single document, no Bill of Rights you can point to and say, there it is, that's my protection.
Which I think for most of us listening, that sounds like a very shaky foundation for liberty. How is freedom even guaranteed if it's not written down somewhere?
They rely on this concept of negative liberty. And this is the core idea. An individual is fundamentally free to do whatever they want, unless a specific existing law explicitly says you can't.
So freedom is the default.
Freedom is the default, unlisted state. Constraints are what require legislation. It's the absence of a constraint that actually defines your right.
So if I want to protest, for instance, my right to do that isn't granted by some document. It just exists because Parliament hasn't passed a law forbidding that specific kind of protest.
Precisely. The state has to justify the constraint, not the individual justify the freedom. Now, this reliance on an unwritten, evolving system leads directly to the core tenet of the English system, parliamentary sovereignty.
And that means the English Parliament is legally, omnipotent.
All-powerful. That's the term, omnipotent, all-powerful.
So if Parliament is omnipotent, where on earth does that leave the courts?
And this is the critical legal distinction, the one India really had to grapple with. In the UK, the courts cannot declare a law passed by Parliament to be invalid or unconstitutional.
At all.
They just lack that power of judicial review over the legislature.
Wow. So if Parliament, which is supposedly the supreme voice of the people, decides to pass a profoundly unfair, even an oppressive law, the courts just have to enforce it.
Absolutely. The courts only protect individuals against the executive.
So government officials, police.
Exactly. They make sure the bureaucracy is acting within the bounds that Parliament set. But they provide zero legal protection against the legislature itself.
So your only option is political.
Your only recourse against a tyrannical law is political. You have to vote them out. It's not a legal fight you can win in court.
Okay, so now we cross the Atlantic to the American model, which is born out of a profound rejection of that very idea.
A rejection of an all-powerful government, yes. The American founders had this intense, deep-seated fear, not just of a king, but of legislative tyranny.
The tyranny of the majority.
The tyranny of the majority. And that fear dictated everything about the American model. First, they went for specificity. Codification.
The Bill of Rights.
The Bill of Rights, first 10 amendments, a specific written list of freedoms. This was meant to be a clear, unambiguous boundary that the government could not cross.
And crucially, this written protection was aimed at restricting the power of both the executive and the legislature. The framers basically assumed that the popular will, expressed through a legislature, could be just as dangerous to liberty as a decree from a king.
Exactly. And to make sure that the legislature couldn't just, undo those protections on a whim, they established the principle of judicial supremacy.
Which we all know from Marbury v. Madison.
Right. In the U.S. system, the judiciary is supreme because it is the ultimate interpreter and guardian of the Constitution. It can declare laws passed by the legislature void if they violate those written rights.
So the Constitution becomes this high wall that the legislature can't move, and only the judiciary gets to say where the boundary of that wall is.
Yes, and they define it over centuries through case law, often expanding rights or defining limitations.
Okay, so let's summarize that conflict. England trusts Parliament completely, making it supreme over the law.
Right.
The U.S. trusts the written law completely, making the judiciary supreme over Parliament.
And India, a new nation needing massive social reform but also terrified of oppression, had to somehow thread a needle right between those two extremes.
And that transition to the Indian Compromise is where you start to see the really bespoke nature of the Indian Constitution. India looked at both of these models and essentially said, okay, we need the absolute protection and the enforceability of the U.S. model.
Yes.
But we also need the flexibility for social engineering that the U.K. model implicitly allows.
And the system that came out of that reflects both India's difficult history under colonial rule, where rights were just routinely ignored, and its vast, almost overwhelming aspirations as a new state facing, immense poverty and social stratification.
So let's talk about the historical push for written rights.
Well, you have to contextualize that demand. The British government, through bodies like the Simon Commission, repeatedly dismissed the whole idea of a Bill of Rights for India.
And what was their argument?
They often argue they were sort of useless, irrelevant, without a strong legal framework to enforce them.
Which was a powerful slight, really. It's suggesting India wasn't mature enough to handle its own rights.
It was. But Indian nationalists, having lived under the colonial regime, knew exactly the danger of a state that wasn't restrained by fundamental limits.
They'd seen it firsthand.
Precisely. Leaders behind the 1928 Nehru Report, for instance, they insisted on a Bill of Rights because they had experienced a subservient colonial-era legislature being used to enact profoundly oppressive laws.
So the threat was real, it was immediate.
It was. So the moment the Constitution was drafted, India adopted fundamental rights and put them right in Part 3, making them central, non-negotiable guarantees.
And the practical effect of that was to immediately limit both the executive and the legislature, building that high wall of protection that the U.S. model is known for.
And this brings us to the core structural compromise, that tightrope walk you mentioned earlier.
Right.
India deliberately sought a balance between English parliamentary sovereignty and American judicial supremacy.
We didn't want a parliament that could, just on a simple majority whim, obliterate fundamental freedoms.
No.
But, and this is critical, we also couldn't afford a judiciary that could completely paralyze the government's ability to legislate necessary, urgent social and economic reform, things like land redistribution.
That tension defined the entire compromise. So Indian courts gained the full power of judicial review.
The strong American defense mechanism.
They can declare a law void if it violates the Constitution, particularly Part 3. That's the American side.
But, and this is the key difference from the U.S., the Indian parliament keeps this massive power to legislate within the boundaries the Constitution sets.
Right. It's not totally at the mercy of judicial definitions of these abstract, absolute rights. And that leads us to the mechanism of restriction,
which is found primarily in Article 13.
Yes. The legal key that maintains this boundary is Article 13. This is the non-negotiable check on legislative power.
So let's get into Article 13, specifically Article 13.2. It's often called the Void Clause, and it's beautifully simple and, from the state's perspective, terrifyingly effective.
It's direct and absolute. It says the state cannot make any law that takes away or abridges the fundamental rights in Part 3, period. And if such a law is made,
Even if Parliament passed it unanimously.
it doesn't matter. It is automatically void, invalid, non-existent to the extent that it contravenes those rights. The Constitution itself is the circuit breaker.
Now, compare that to the U.S. In the U.S., rights were initially seen as these absolute barriers. So if the government needed to restrict a right for, say, national security, it was the courts who had to develop these complicated legal tests, like clear and present danger, to invent those limitations.
The Indian Constitution took a vastly more practical, almost preemptive approach to this.
Yes.
Instead of assuming rights are absolute and then making the court define the necessary limits, the Constitution itself gives the legislature the power to impose reasonable restrictions on many of the rights.
Can you give us an example of how that's written right into the text?
Sure, look at Article 19, the right to freedom. It guarantees freedom of speech, assembly, movement, and so on. But right after those guarantees, the text lays out the grounds on which the state can impose reasonable restrictions.
Things like public order, morality.
Public order, morality, security of the state, sovereignty and integrity of India, it's all spelled out.
So Parliament is empowered from the start to restrict, say, freedom of movement if it's reasonable to do so for public health reasons.
Right, and it's not a grant of power from the judiciary. It's a defined power in the Constitution itself.
Which shows a certain practical trust in the legislative process.
It does, while still keeping the critical check.
Mm-hmm.
Those restrictions must be reasonable. And who defines reasonable? Ultimately, the judiciary does.
So that creates the dynamic dialogue.
That's it. Parliament passes the restriction, the courts check its reasonableness and proportionality. That is the Indian Compromise in action.
And the moment that dynamic dialogue turned into a full-scale war was over land reform and the right to property.
Absolutely.
The goals of a new nation trying to redistribute land and wealth ran headlong into the guarantees of Part 3. And this collision led to the most dramatic conflicts in constitutional history.
The story of the right to property isn't just some legal footnote. It is the constitutional flashpoint that caused the creation of doctrines that restricted Parliament's own power permanently.
Okay, so let's start with its original status.
Originally, the right to property was a fundamental right. It was enshrined in Articles 19(1) and 31. This guaranteed that property couldn't be taken without authority of law, and that any such acquisition could be challenged directly in the Supreme Court.
But post-independence, the government's push for agrarian and economic reform was relentless. Land ceilings, nationalizing industries, all of this required the government to acquire huge amounts of private property, often with very low compensation.
And that goal was just fundamentally incompatible with a strong, enforceable property right.
So this conflict led to a series of amendments trying to shield these laws from the courts.
Yes, all through the 50s and 60s. But the final definitive blow came with the 44th Amendment in 1978, passed by the Janata government. This amendment physically removed the right to property from Part 3 entirely.
Gone. So it was no longer a fundamental right. What did the Constitution do with it then?
It was moved and re-enshrined in Article 300A. And there, it was deliberately downgraded to a simple legal right, or you could call it a constitutional right, but critically, not a fundamental one.
And the consequences of that demotion are profound.
Oh, absolutely. For any individual whose property is taken, it changes everything.
Let's define those practical consequences clearly for everyone listening. What's the biggest change?
The most immediate one is the remedy. If the government seizes your property illegally, you lose your constitutional fast track. You can no longer go directly to the Supreme Court under Article 32.
And Article 32 is the guaranteed remedy for fundamental rights.
Correct. Instead, you have to go the slower, more difficult route through the High Court using Article 226, or file a traditional civil suit, which can take, years. The power of immediate constitutional protection is just gone.
And what else? You mentioned the test of reasonableness.
Right. And this connects back to what we were just saying. Since property is no longer a fundamental right, you can't challenge a law that takes your property on the grounds that the law itself is unreasonable or unfair or disproportionate.
So as long as the legislative process followed the rule.
The law stands, even if it feels incredibly harsh.
And this is also all tied up in the debate over compensation, wasn't it?
Indeed. Originally, the state had to pay compensation. But the government hated that word because it implied fair market value, which they simply couldn't afford for massive land reforms.
So they changed the word.
The 25th Amendment changed the word compensation to amount.
A semantic change, but a strategic masterstroke.
It was. because it allowed the state to argue that an amount could be anything, even a nominal sum, and the courts couldn't step in to demand fairness.
You could challenge the fairness of compensation, but you couldn't really challenge the fairness of a mere amount.
It became judicially impossible for a long time. Then the 44th Amendment came along and essentially removed even this diminished protection entirely, solidifying the state's commitment to socioeconomic reform over individual economic liberty.
So what was the philosophical justification the government used for this?
The justification was that by removing property rights from this untouchable list, they were empowering the legislature, the elected body, to become the true guardian of rights, prioritizing the collective good over individual wealth.
And this is where the critical analysis comes in. The author we're referencing argues that this reasoning just completely undermines the whole premise of fundamental rights.
It does, because the very purpose of having fundamental rights is based on the idea that elected majorities in a legislature are not infallible.
Right, they can be tyrannical.
They possess the unique capacity for tyranny against minorities or specific interests. That's the whole point.
So if the elected body becomes the ultimate decider, the right isn't a fundamental guarantee anymore. It's just a temporary privilege granted by whoever is in power at the moment.
It's a profound conceptual difference. And the fight over property exposed this deep fault line in the constitutional structure.
Was the Constitution just a document defining procedures, or was it a document defining absolute, unamendable value?
That was the question. And it led directly to the confrontation over Parliament's power to change the Constitution itself.
Initially, what was the established legal view on that? Could Parliament amend anything?
For the first, say, decade and a half, the judiciary basically assumed that Parliament had unrestricted power to amend any part of the Constitution, including the fundamental rights section.
A lot of faith in the elected body.
There was. But the relentless push for land reform laws that kept colliding with Part 3 led to this massive shift in judicial thinking in 1967.
The landmark Golak-Nath case.
Yes. In a dramatic reversal, the Supreme Court ruled that fundamental rights were transcendental.
Meaning
They existed outside the normal realm of legislative action and therefore could not be amended by Parliament. Period. They put the rights beyond legislative reach.
which created an immediate constitutional crisis. If Parliament, the sovereign body, couldn't change the constitutional text to enable its policies, the government would be paralyzed.
So the government responded with equal force. They passed the 24th Amendment in 1971, specifically designed to nullify the Golak-Nath verdict.
And this amendment did what exactly?
It explicitly asserted Parliament's power to amend any provision of the Constitution, including those related to fundamental rights. This was the legislative branch pushing back with all its constitutional might.
So you have this confrontation, the judiciary saying rights are unamendable and Parliament responding by saying everything is amendable.
And that set the stage for the single most crucial decision in Indian constitutional history, the Kesavananda Bharati case in 1973.
The ultimate constitutional stare-down.
It was. The court had to choose. Either cede total authority to Parliament, confirming the 24th Amendment's power, or rigidly maintain the judicial supremacy from Golak-Nath.
And they chose a middle path, which has defined the system ever since, a razor-thin 7-6 majority verdict, but the impact was monumental. The court upheld the 24th Amendment. They confirmed that Parliament can amend fundamental rights. It rejected the absolute prohibition of Golak-Nath.
This is the catch. This is the doctrine that has permanently limited India's elected representatives.
Basic structure doctrine.
Basic structure doctrine. The court said Parliament cannot alter or destroy the basic features or basic structure of the Constitution. It can amend, but it cannot mutilate.
This is a remarkable, arguably extra-constitutional judicial invention. It's defining an unwritten boundary. Help us understand the philosophy here. I mean, isn't the judiciary just inventing law? If basic structure isn't explicitly written, how is it really constitutional?
That is the perennial question, and it really speaks to the doctrine's novelty. The court argued that you have to read the Constitution as a coherent document with an inherent identity.
Okay.
The basic structure is just the collection of those features, democracy, secularism, judicial review, that define the document's identity. If you destroy those, you haven't amended the Constitution, you've replaced it.
And what are the implications for fundamental rights specifically?
The court ruled that fundamental rights are part of the basic structure. So Parliament can amend them. It can reduce the scope of a right or introduce new reasonable restrictions, but it cannot abrogate or destroy them entirely.
It allows for constitutional evolution without allowing extinction.
Exactly. And the doctrine also provides the judiciary with its ultimate self-defense mechanism.
How so?
Well, the separation of powers between the executive, legislature, and judiciary is also deemed a basic feature. So if the executive or parliament tries to consolidate too much power, say, by stripping the judiciary of its review powers, the court can strike that down as a violation of the basic structure.
That's fascinating.
They even linked an attack on judicial independence to a violation of the right to equality under Article 14. So they're using existing rights to protect the structural integrity of the Constitution itself.
The basic structure doctrine gave the judiciary the hammer. Now let's move from those grand battles to the specific operational details. Who was protected, what the protection covers, and who the protection is against.
Right. So the Constitution originally organized the fundamental rights into 7 classifications, although we have to immediately note the removal of the property right.
So we have the right to equality, the right to freedom, the right against exploitation, right to freedom of religion, cultural and educational rights, and the ultimate enforcement tool, the right to constitutional remedies.
And it's crucial to note the dual nature of these rights. Many are phrased as prohibitions on the state.
The state shall not discriminate. The state shall not deny.
Right. These are negative commands telling the government what not to do. It reinforces that concept of negative liberty we talked about.
But others, especially with newer interpretations, they imply positive benefits. They're mandates for the state to act.
Exactly. Guaranteeing the right to education or ensuring cultural rights might require the state to spend money, build schools, or actively facilitate a particular freedom.
So it's a comprehensive document for both restricting government overreach and compelling positive state action.
That's the dual nature, yes.
Now, let's talk about who gets these rights. Who is the beneficiary? Because not all rights apply to everyone within Indian territory.
This is a subtle but very important legal classification. Certain rights are reserved exclusively for citizens only.
Okay, what kind of rights are those?
These are the core political and national identity rights. The prohibition of discrimination under Article 15, equality of opportunity in public employment under Article 16, the core freedoms like speech and assembly in Article 19, and minority rights in Articles 29 and 30.
So if I'm, say, an American visitor in Mumbai, I don't have the right to freely assemble guaranteed by Article 19.
Correct.
But I do have other fundamental protections.
Absolutely. A significant number of rights are available to all persons, which includes citizens, foreigners, and sometimes even legal entities like corporations.
And this would be things like...
Article 14, equality before law. Article 20, protection and conviction for offenses. Article 21, life and liberty. And Article 25, the right to religion. This ensures that even non-nationals are afforded basic human dignity and due process.
Okay, so since these rights are primarily guarantees against the state, we need to define what the state even means.
Right. Article 12 provides that necessary definition. And this is crucial because if a body is not the state, fundamental rights generally can't be enforced against it.
And the definition has to be broad enough to prevent the government from, hiding its actions behind various administrative masks.
And it is broad. It starts with the obvious. The government and Parliament of India, state governments and legislatures, and local authorities like municipalities and district boards.
But the courts had to deal with all these quasi-governmental bodies, organizations that act like the state but aren't formally part of it. This is the other authorities clause, right?
Correct. And the courts have interpreted other authorities very expansively. It can include bodies that have the power to make binding rules or regulations, or which perform functions very close to those of the government, often with deep state financial support or control.
Can you give us a concrete, relatable example of an other authority?
Sure. Think of a major public sector undertaking like the Oil and Natural Gas Corporation, ONGC, or a statutory body like the Life Insurance Corporation, LIC, or even state-run universities. If these bodies terminate your employment or enact some arbitrary rule, their actions can be challenged in court for violating Articles 14 or 16 because they are deemed the state under Article 12.
So it really increases accountability, but there has to be a limit.
There is. The courts have drawn a line carefully. For instance, a purely private entity, even if it's heavily regulated, is usually exempt. The source notes a specific exclusion for unaided private minority schools from the Article 12 definition to protect their autonomy.
Okay, let's turn to Article 21, the protection of life and personal liberty. You said this is maybe the most powerful and transformative article in the Constitution.
It is, and it's almost entirely because of judicial evolution. Its expansion is a clear reflection of the judiciary's shift from an approach that deferred to Parliament to one that actively tests the fairness of legislation itself.
So what was the old view?
In the early days, we saw this very narrow view, like in the 1950 case of A.K. Gopalan. The court held that Article 21 only provided procedural protection. It stopped the executive from acting without a law, but the legislature could pass any law it wanted to take away liberty, even an unfair or draconian one. As long as the procedures in the law were followed, even bad procedures, the court couldn't intervene.
So if Parliament passed a law saying X person can be detained for Y reason, the court's hands were essentially tied, even if the law was manifestly unjust.
That's it. It was procedural justice, nothing more. But that doctrine was utterly dismantled in the late 1970s, especially in the Maneka Gandhi case.
The new expansive view.
Exactly. The Supreme Court ruled that a law taking away liberty must not only be a valid law, it must also be reasonable, fair, and just. This was a monumental move from procedural due process to substantive due process.
How did the court justify that radical move without just rewriting the Constitution? What was the legal mechanic?
The court created what's called the Golden Triangle Nexus. It linked Article 21, Life and Liberty, with Article 14, Equality, and Article 19, Freedoms.
I see.
The argument was this. Any procedure established by law for taking away liberty cannot be arbitrary, or it violates Article 14. If it's arbitrary, it's not fair. And if it's not fair, it cannot be a valid procedure established by law under Article 21.
So every law that restricts liberty is now subject to judicial review based on its inherent fairness and proportionality. That is a massive transfer of power back to the judiciary.
It is. And the expansion has been relentless, bringing all these unwritten rights under the umbrella of life itself.
Like what?
We now see derived rights like the right to a speedy trial, the right against solitary confinement, the right to medical care, right to shelter, even environmental rights like the right to clean air and water, all flowing from the expanded scope of Article 21. It's become the constitutional repository of human dignity.
Okay, so having defined the expansive reach of these rights, we have to talk about the constitutional provisions designed to shield certain laws from this powerful judicial review, the immunities.
We're looking at Articles 31A, 31B, and 31C. They are the protective armor for certain legislative actions.
What do they do?
Well, Articles 31A and 31C basically say that laws made for agrarian reform or to implement the directive principles, those non-enforceable policy goals, cannot be challenged even if they violate Article 14, Equality, or Article 19, Freedoms.
A necessary protection to get reforms done.
It was seen that way to prevent reform from being tied up in litigation by landowners.
And then there's the infamous Ninth Schedule under Article 31B, the constitutional vault.
That's a great way to put it. Article 31B says that any law placed by Parliament in the Ninth Schedule is immune from challenge based on fundamental rights. Historically, this meant those laws were totally safe from judicial review.
A tool that was originally meant to protect land reforms, but was later used for politically sensitive legislation.
It was. But the Kesavanavarati verdict left a key opening, limiting the potential abuse of this vault.
And what's that crucial caveat?
The caveat that everyone must remember is this. Laws placed in the Ninth Schedule after the date of the Kesavanavarati ruling, that's April 24, 1973, can still be challenged if they're found to violate the basic structure of the Constitution.
So the judiciary basically signaled it would not allow the Ninth Schedule to become a tool for destroying the core democratic framework.
Precisely. Parliament can still use the vault, but for laws passed after 1973, the judiciary reserves the right to check if the vault is being used to hide something fundamentally unconstitutional.
Okay, let's move briefly from immunities to obligations. We have to touch upon fundamental duties, Article 51A.
Yes, added later by the 42nd Amendment in 1976.
And these duties, like respecting the flag, promoting harmony, protecting the environment, these are obligations on the citizen, not restrictions on the state. And they're generally seen as non-enforceable.
They are not directly enforceable, that's correct. You can't be sued for failing to protect the environment just by invoking Article 51A. However, they carry significant indirect judicial weight. Courts often use them as an interpretive tool. More critically, if a person comes to court seeking to enforce a fundamental duty, but they themselves have been in egregious violation of a fundamental duty, the court may, in its discretion, take that into account and refuse to grant them the remedy they're seeking.
It creates a subtle but important balance between rights and responsibilities.
It does.
Okay, we've established the primary target of fundamental rights is the state, but there are crucial exceptions where these rights protect you against private individuals.
And these exceptions are vital for tackling deep-seated social inequality. Key examples are Article 15.2, which grants citizens access to public places like restaurants and shops, regardless of caste or sex.
And untouchability.
Article 17, the absolute abolition of untouchability. And Articles 23 and 24, which prohibit human trafficking, forced labor, and child labor.
So if a private temple denies me entry based on my caste, I can invoke Article 17, even though the temple is not the state.
You can, but here's the legal mechanism. These specific social rights are not always self-executory. Parliament has to pass specific legislation to define the punishment and the machinery for enforcement. The Protection of Civil Rights Act, for example, is the law that gives teeth to the constitutional mandate against untouchability.
I see. And lastly, in this section, we have to detail the powerful addition of Article 21A.
Yes, inserted by the 86th Amendment in 2002. Article 21A formally made the right to free and compulsory education for all children between 6 and 14 a fundamental right.
Moving education from a policy goal to an enforceable guarantee.
And that led to the Right to Education Act in 2009. The Supreme Court upheld the act, but it had to balance this new right with the existing fundamental right of minority groups under Article 30 to establish their own educational institutions.
Meaning the Right to Education Act, while valid for most schools, couldn't be forcibly imposed upon minority schools.
Exactly. It maintained that delicate balance between social mandates and cultural autonomy. It's yet another example of the court mediating between two competing, yet equally fundamental constitutional rights.
Okay, so we've used the terms fundamental right and constitutional right almost interchangeably, but in the Indian legal context, the practical distinction is everything.
This is the most practical and crucial takeaway for anyone trying to understand the power structure. The true strength of any right is measured by the ease and effectiveness of its remedy.
It's the difference between direct access to the highest court and a long, difficult legal battle.
So let's define them simply. Fundamental rights are those enshrined specifically within Part 3 of the Constitution. Their specialty is the automatic, guaranteed remedy available under Article 32.
And then we have constitutional rights. These are legally enforceable because they're in the Constitution, but they live outside Part 3.
Examples would be Article 265, no tax without authority of law, Article 301, freedom of trade and commerce, and of course the most famous example of a downgrade, the right to property in Article 300A.
These are major legal rights, but they lack that fundamental hammer that defines Part 3.
And that leads us to the difference in remedies. If a fundamental right, one in Part 3, is violated, the Constitution sees this as such a grave matter that you can bypass all the lower courts and go directly to the Supreme Court under Article 32.
And that article, the right to constitutional remedies, is itself a fundamental right. It's the guarantee that your guarantees are enforceable.
It is. But if a constitutional right outside Part 3 is violated, if the government levies an illegal tax or illegally demolishes your property under Article 300A, you are explicitly barred from using Article 32.
So what's your path then?
You have to pursue the normal judicial route, file a traditional civil suit in a lower court, or approach the high court under Article 226. And while Article 226 is powerful, access to the high court is a general legal provision, not a guaranteed fundamental right. It's a slower, more discretionary path.
And this distinction really underscores why removing the right to property from Part 3 was one of the most consequential political moves in Indian history.
Absolutely. It didn't abolish the right entirely, but it strategically removed the most potent judicial defense available to citizens.
So we've journeyed from the global extremes, the UK's parliament-centric negative liberty model versus the US's written judiciary-centric model, and we've seen how India constructed this unique middle path designed for both stability and social change.
And the key nuggets we've uncovered include the power of Article 13, too, to just automatically nullify infringing laws, the philosophical genius and permanent constraint of the basic structure doctrine. And that radical judicial shift that expanded Article 21 into the most powerful guarantor of substantive fairness and human dignity in the entire Constitution.
And we tracked the long, dramatic, and often painful decline of the right to property, which was moved to Article 300A to prioritize the state's goals of social engineering over an individual's economic protection.
In this specific decision, the reduction of property from fundamental to merely legal status is particularly unique in the global democratic landscape. It leads us to our final provocative thought for you to consider. Globally, and increasingly in recent human rights discourse, property, the ability to own and retain one's economic fruits securely, is being framed as an inherent human right,
Hmm.
necessary for dignity and freedom from state coercion.
Right.
This trend contrasts sharply with the specific decisive choice made by the Indian Constitution to strip property of its fundamental status and judicial immediacy. So the question is this: what does this long history, filled with parliamentary muscle flexing and the eventual judicial counter-limitations, ultimately tell us about the necessary, unending tension between the state's urgent need for rapid economic transformation and the sanctity of individual guaranteed liberty?
A tension that continues to define India today.